I'll start. Hello, everyone. We wanted to make sure that the recording was going before we actually got going here, because this webinar will eventually be posted on YouTube for others to see down the road. Let me start by introducing myself. My name is Frank Montero. I'm a partner here with the law firm of Fletcher, Heald and Hildreth. And I have with me my partner, Karin Ablin, who is really going to be the star of today's presentation. Before we get started, for those of you who are not familiar, this is the most recent in a series of webinars that we do for the Colorado Broadcasters Association. Fletcher, Heald and Hildreth is counsel for the CBA here in Washington, D.C. And we have a whole series of resources that are available to members of the CBA that make the membership in the association, I think, worthwhile. Among other things, we have a blog, Common Law blog, and I urge all of you who are on to subscribe. That's free for subscription. You'll get updates and news about what's going on at the FCC, intellectual property, Congress, telecommunications issues, and things like that. And then also we have a YouTube page, and on there you will find a large number of our prior webinars that we've done for the CBA and for other state associations. But you go to YouTube and just search Fletcher, Heald and Hildreth. You'll find our YouTube page there, and you'll find a whole library of different webinars. And as I mentioned earlier, this webinar will eventually be uploaded onto that YouTube page as well. I want to, before we get started, thank the Colorado Broadcasters Association and your fearless leader, Justin Sasso, for help putting this all together. CBA is a fantastic organization. If there's any of you on here who are not yet members of the CBA, highly urge you to join. There's a whole battery of different benefits that come along with it, including a legal hotline that our firm provides to members of the Colorado Broadcasters. Our presentation today is going to be roughly about 60 to 70 minutes. And then we're going to try, as time allows, to pause to take questions and answers as we're going through. But we'll primarily be leaving some time for Q&A at the end of our presentation. And so, if you want to ask a question, wherever it's located on the navigation bar on your screen, there should be a Q&A function there, and you can type your questions there. We're urging people to use that as opposed to the chat function to log your questions, and that's where we'll be looking as we're going along. So with that, some of the topics that we're going to be covering today will include the basic building blocks of copyright law, how to approach content licensing, that is, how to approach the licenses that you will obtain from the various performing rights organizations that are out there, ASCAP, BMI, SoundExchange, etc. Then we are going to look at musical works performance licensing for radio, both for commercial and non-commercial stations. We put radio there, although a lot of this will apply, can also be applicable to television as well. And then the musical works performance, that's the stuff that many of us as broadcasters are familiar with. That's the ASCAP, BMI, CSAC, now GMR rights that you pay for. But then in addition to that, we're going to be looking at the performance rights, the recording rights. That's the sound recording performance licensing. That's the SoundExchange part of the puzzle. And we're going to be doing that for both commercial and non-commercial stations as well. And we're going to talk about the distinction between what falls into number 3 and what falls into number 4. So with that, I'm going to turn it over to our host today and my partner, Karin Avelin, to walk us through some of these issues.
Thank you, Frank. It's a pleasure to meet with you all over the internet, and hopefully you'll get something useful out of this. Starting with item 1, which is the building blocks of copyright law. Before we launch into the performance licenses that radio stations need, you need to have kind of a rudimentary understanding of where those licenses come from and why you need them. So copyright law, it is granted by federal statute, and it is different from patent and trademark law. Those are different types of protection. We're not going to get into those here, but for copyright law, it protects what's known as a work of authorship. And there's a lot of different types of works that qualify. We'll look at some examples of those. But the most important thing to be protected under copyright law is that the work be original. It's got to exhibit some degree of creativity. You cannot protect a phone book, for example. And it has to be independently created by the author, who then gets rights in it. A copyright does not inhere in simply an idea. The idea has got to be either written down or recorded. It's got to be fixed in a tangible medium of expression. And that's defined under the law as sufficiently permanent or stable to permit the work to be perceived, reproduced, or otherwise communicated for a period of more than transitory duration. So it's got to be fixed. And some of the works that are protected by copyright, we're going to talk about 2 of them in particular here, but copyright protects literary works, which are things like books, poems, news articles, what have you, pictorial works, which mainly are photographs, audiovisual works like television shows or news clips, movies, and then the last 2, which we're going to focus on here, are musical works and sound recordings. And these works are listed in, if you would like to see the full list, they're in section 102 of the Copyright Act, which is found in Title 17. So musical works versus sound recordings. Every time you play or copy or what have you a piece of music, it implicates 2 different types of copyrighted works in that recorded song. There is the musical work, which, as you see by the picture on the left-hand side, it's the words and notes, words if there are any, or the notes that a composer writes down and a publisher commercializes typically. So the copyright owner of musical works, they're typically publishers and composers. A sound recording, on the other hand, is the noise that goes on an album, a disc, a file. It's a specific recorded performance of a musical work. So the example I like to give is the song "I Will Always Love You" that Dolly Parton actually wrote, and her publisher has rights to that song, the musical work. But the person who made it most famous is Whitney Houston when she sang it on the soundtrack of The Bodyguard, "I Will Always Love You." So Whitney Houston and her record label have the rights to the sound recording there. And believe it or not, you can actually play the Dolly Parton version of that song, which was somewhat successful too. But if you say that song, people think of The Bodyguard and Whitney Houston.
Just to kind of interrupt you here for a second, Karin, because this is actually the part that I find when I'm talking to clients confuses people the most, because that with the musical work, the actual, the writing, the song that Dolly Parton wrote, for example, that's the stuff that is usually covered by things like ASCAP, BMI, CSAC, that sort of thing, right? That's what we're talking about. That's not the recording. The recording is a completely different animal, and one of them broadcasters pay, and the other one currently broadcasters don't pay. And I know you're going to be talking about that more, but that's sort of the distinction here, right? Because the sound recording, that's not ASCAP, BMI, CSAC. That's Sound Exchange, right?
Yes, that is correct.
That's what I thought.
Yes, and specifically for the performance rights, which is what we're focusing on. But yes,
right.
For the performance rights, those are the organizations Frank mentioned is where you would go to license those rights. Right. And we'll get into that in more detail. So then, once you are familiar with the works covered by copyright, you also, in looking at content licensing questions, need to know what types of uses or rights does the copyright owner in those works have. And the rights are listed in section 106, and they include publicly performing the work, which is the one we're going to focus on here, making copies of that work, distributing those copies to the public. For example, if you make a copy of a pamphlet and you hand it out, that would implicate one of the exclusive rights of the owner. Preparing derivative works. So if you would like to take a book and turn it into a movie, for example, or even modify a book to make a satire, that would implicate the derivative work right. And then publicly displaying the work. That would be, for example, a statue. If you want to, somebody's made a sculpture and you would like to publicly display it, whether in person or perhaps online, that implicates the copyright owner's copyright rights. But for purposes of this webinar, we're focused on the first listed right, which is the public performance right. If you've got questions about those other rights, feel free to contact us afterwards and offline.
Yeah.
So this slide capsulates, this is a general slide before we get into the specifics of radio. If you're faced with you want to use somebody else's content or something you found on the internet, this outlines an approach that you can take to figure out how to license, how to get the licenses that you need. So you start with identify the content or the material that you would like to use. Make sure it falls into one of the categories, of the works that we listed, whether it's a photo, a news clip, something in writing, or a song. So you figure out what you want to use. Then you determine whether that material is protected by copyright. Some things that are very old, for example, some older classical music, the original arrangements of that would not be protected by copyright, and you wouldn't need to go to a copyright owner or the heir of that copyright owner to license rights. So you find out which works you want to use and whether you need to worry about copyright protection and getting a license. After you've done that, then identify each way in which you would like to use those works. For example, in radio, you might want to perform a work over your broadcast or your webcast. You might want to make a podcast. You might want to post a news article. So those all implicate different types of rights. If you perform, then you need to get a public performance right. If you display, you need to make sure you've got a public display right. And if you make copies of something, either to distribute or not, if you're just copying something and posting it on your website, that would implicate the copyright owner's rights. And then the matrix that you see below item 4, it's simply a crosshatch of the works that you're using, the content that you want to use versus the ways in which you want to use it that implicate the owner's rights. And you come up with this nice this matrix here. I've done one, for example, that, might apply to podcasting, a bit of music, a piece of music, because a podcast implicates making a public performance, making a copy of that. If you're delivering it to someone, you're making a copy and sending that copy to someone. And then if you're offering it publicly, you'd be publicly distributing those copies. And if it's a piece of music, you need to worry about the two types of works that inhere in that music, both the musical work and sound recording side. So once you've got your matrix, then you just need to check all those blank boxes to make sure that if you need to license that right, that you've got the right license. So the shortcut for this whole slide is if you don't want to mess with it, then call us and we'll help walk you through that process. That's what we're here for.
So before we go into more detail on the music work licensing, just want to check to see if there were any questions on some of these basic building blocks, just kind of because it can be a little confusing between all the different types of licensing that are out there. None? Okay, we'll keep on going.
We will charge ahead. I get control back. Okay, so there we go. Okay, so we're going to start with the musical work side of music and talk a little bit about musical work licensing, the performance right, and how that implicates radio stations. And we'll start with commercial radio. And then when we're finished with commercial, we'll touch on non-commercial, because there are separate kinds of licensing mechanisms that apply to each. So for commercial radio, musical work licensing, as Frank mentioned earlier, those rates typically are negotiated with 4 main performing rights organizations, and they're listed on here with their logos: ASCAP, BMI, SESAC, and Global Music Rights, the newest one. ASCAP and BMI, as you probably know, are much, much larger than the other two. They each have somewhere between 40 and 45% of the market. And SESAC is a lot smaller. It's got a few percent of the market. Global Music Rights, despite the splash it's made in the media over the past few years, it's got less than 1% of all songs that have been written in its repertory. So it's teeny tiny, but its business model was to go out and basically pick off the songs that people most want to play and come up with some sort of premium catalog that they can then charge an outsized share vis-a-vis their market size, as to ASCAP, BMI, and SESAC. So we'll get into that.
Hey, Carl, let me ask you a question, because if you're old timer like me, I remember when SESAC was the new kid on the block, and
Yep.
SESAC at the time had carved out a niche for themselves with Spanish music. In fact, that was sort of their way to kind of get their nose under the tent. And now we have Global Music. Are we done, or are we going to see a 5th one and a 6th one and a 7th one? I mean, when will this stop?
So I wish I could say we were done, but in fact, about a year or so ago, there was a 5th,
Right?
an alleged 5th PRO called Pro Music Rights. And I think they're still kind of bopping around there. And they claim to license a catalog of essentially rap and electronica music. And they went around offering these exorbitant licenses that were much higher, I think, than any of these other groups were offering for a truly small catalog. And nobody took them seriously. So they brought a lawsuit against essentially every music user and every major music user in the industry. Our firm represented one of those groups that was sued. Fortunately, that case got thrown out very early on a motion to dismiss, and it went away because most of those groups, there were a lot of problems with it. Most of those groups at least have a lot of radio stations, for example, don't play rap music, and the ones that do can have another conversation. But there were a lot of reasons why that got thrown out, but there is nothing inherent in the system stopping another PRO from forming. And in fact, as the last 2 bullets on this slide say, each of these 4 groups represents its own set of works. And so you can't just get an ASCAP license and think you're done. It's like a pie that's been divided up into 4+ slices. And the reason I'm saying 4+ is because not all works are represented even by these 4 groups. There's a little sliver of usually, like independent writers or whatever that is not included, but typically those people, it just has not been a business issue for the people that are unaffiliated. They're so small, or they eventually do affiliate. But there's also nothing stopping someone who's they're represented by BMI from moving their catalog under certain circumstances, and that's essentially what GMR did. They rated a lot of works, I think largely from ASCAP, probably some from BMI and SESAC, but they really bit into ASCAP's market share. So, and that's why, because they each have their own catalog, you need a license from each of these 4 organizations if you play their music that they represent. I tell people, with the possible caveat of GMR, because they're so small, it might in theory be possible for you to clear your performances of their music. The pitfall with that is, if you run any syndicated programming where you're not controlling the music that gets baked into that programming, it's really, really hard to clear. And GMR now is probably kind of on the prowl looking for people who didn't sign a license to see if they're slipping up.
Could this be impacted even if there's like music in a commercial?
Well, the music and commercials would be covered if
Okay.
it's otherwise in these catalogs.
Okay.
But if it's not, if it's just getting performed.
Right.
If someone's producing a commercial, that's beyond the scope of what we've got time to talk about today. It implicates other rights that you can't license through ASCAP, BMI, CSAC, and GMR. But if you're just performing someone else's commercial and that person has gotten those other extra rights, and you know, the music otherwise is represented by one of these 4 PROs, it should be okay.
Okay.
So starting with ASCAP, BMI, and CSAC, we'll just get into a little bit more detail about the types of licenses they offer. So the first 3 PROs you see on this slide, they offer 2 types of licenses, essentially. They're called, with ASCAP and BMI, blanket and per program. If you're a music intensive station, you're likely, very likely, under a blanket license. As it says on the slide, that's an all-you-can-eat license. You pay a fee, you can play whatever you want out of that catalog, and it's based on a percentage of your station's revenue. We're talking about broadcasting now. We'll get into webcasting in a second. There's also a per program license that's offered, and that would be primarily for stations that have a very significant portion of their programming that consists of news, talk, sports, something that doesn't use music. And those rates can often save you money, particularly one form of those per program licenses. And GMR rates, on the other hand, are charged by flat fees. So you don't need to track your revenue. You just pay a dollar amount that they send to you, and we'll get into them in a bit here. One thing that I think a lot of stations may not know is there are 2 forms for both those blanket and per program licenses for ASCAP and BMI, and soon GMR, but not CSAC. There are 2 different license committees that negotiate these licenses. And if the Radio Music License Committee is probably who you're more familiar with, because they handle most of the industry. They negotiate licenses that most commercial stations will take. On the other hand, if you're a religious station or a mixed format or a talk station, even if you're not religious, there's another group, the National Religious Broadcasters Music License Committee, we represent them, that negotiates alternative radio licenses that seem to work best for stations that use less music. So they also come in a blanket and a per program license. The blanket license is very similar to the RMLC license. I mean, maybe differing in just a fraction of a percentage of revenue, but the per program license is quite different, and it is where you can save some money if you decide to have them represent you. But most stations are affiliated or represented by the RMLC.
Connie, can you join RMLC? I mean, are there like admin fees or that sort of thing?
So both of these groups, they're not membership committees, but
Okay.
they take license authorizations from stations, and I believe now both of them, the RMLC, if you accept that license, and that's what you're paying ASCAP and BMI, for example, there's a baked-in admin fee in the license that gets paid and then sent back to the RMLC to make sure it's got money to work, to do its operations. And the NRB MLC, I believe it's also moving in that direction to have a baked-in fee.
Got it.
Because they can't operate for free.
Right.
So so that was about broadcasting. Webcasting is pretty easy for Musical Works. And that's because all the licenses we just talked about, all of them, for all 4 PROs, the webcasting rights are baked in to the broadcasting license. That's true for the licenses offered through the RMLC, and it's also true for the NRB MLC offered licenses. So we are not, this next slide, if you've got your phone out and you want to take a picture of it, feel free. We're not going to go through all of these rates, but generally, in general terms, this slide lays out for the RMLC licenses what the rates are that you would pay. As you can see, the blanket and per program rates are up there. ASCAP and BMI are very similar in price. CSAC is much, much smaller, and GMR charges flat fees that vary by station. And for webcasting, the webcasting, as we said, those rights are typically a follow-on of the broadcast rights with the same the same numbers in terms of the percent of revenue, but there's deductions that apply, and the deductions are a little bit higher for webcast rights. This next slide it looks a lot like the prior slide. It's a replication, but this one portrays the NRB MLC rights. And if you were paying attention to the numbers, the blanket rates are pretty darn close to the RMLC rates, but the per program rates are they can be a lot less for you. And that, in fact, is the reason why that other committee was formed. It was really to represent the interests of stations that use less music to get them some more fee relief. And because the format one of the formats that really implicates is religious, that's why I think it happened through the national religious broadcasters. So you can save some money on your per program rates if you go with them. With CSAC, however, the NRB MLC does not have a separate CSAC license, so the fees you see on this slide are the same. It's the RMLC license. They've decided to join forces on that, and so everybody pays the exact same rate.
So before we jump into the next one, let's see if we have any questions that came up, just because there's a lot here to digest.
Not yet. So far, so good.
Okay.
Okay, so this is relatively, I'll call it warm news off the press because it's a few months old now, but the fees that were posted, that were displayed for the RMLC a couple of slides ago, at least for ASCAP and BMI, they expired in 2021. And so stations are still paying those fees, but on an interim basis. So you might ask, what's going to happen going forward, starting in 2022? Well, glad you asked. The RMLC has engaged in what I think is a pretty smart tactic, because for the first time, you may remember something called the Music Modernization Act. It made a lot of amendments to copyright law. One of those amendments got rid, in our prior world, ASCAP and BMI, and I should mention, they're large enough that they were sued under our antitrust laws decades ago. And they now operate under a consent decree that it initially required a specific judge within the Southern District of New York to oversee them and oversee that they're complying with that consent decree. And ASCAP and BMI had different judges that oversaw them for that. Now, and those judges would also, in addition to overseeing them, would set rates in the absence of an agreement. Now, those specific judges no longer handle rate disputes. If you want a rate dispute, if you would like to bring a rate dispute, you still go to the Southern District of New York, but you're randomly assigned a judge. So the RMLC has said, they've claimed, and this was in June, that, okay, there's no more specific rate court judge to set rates, at least. So let's set ASCAP and BMI rates in the same proceeding, which makes a lot of sense, because what would happen in the past is there would be an ASCAP proceeding, and ASCAP would say, oh, we've got this huge market share. And then they would set BMI rates, and BMI would say the same. But that the numbers, if you put them all together, would add up to more than 100% of a pie. And so RMLC filed a joint action in June. They brought in ASCAP and BMI, and they said, okay, we've made an offer. We're willing to pay them the same number, joint number, take ASCAP plus BMI. And then you, court, we don't care how it's divided up. You figure it out, court, or ASCAP and BMI, you agree to it. And that avoids, I call it whipsawing. I think that's the term the RMLC used. It avoids the ratcheting up effect of one PRO trying to use the rates from another PRO to increase their rates. So it was a pretty clever tactic that hopefully it will succeed, but not if BMI has anything to do about it, because they oppose that approach for all the reasons that the RMLC and radio would like that approach. And they've said, nope, hold it. Even with that change that got rid of those rate court judges, there's still nothing in the consent decrees that permits us to be joined. We're under different decrees and we need to stay separate. And so they are trying to stop that proceeding. They went back to their original rate court judge, who still does have oversight over BMI. And they said, Judge, please construe the consent decree that it doesn't allow this. In the meantime, this lawsuit was stayed. So stay posted. We'll keep our eyes on this and see what happens. But right now, that lawsuit has stayed while the BMI rate court judge considers whether, you know, a joint rate determination like this is permitted under the decree. And then GMR, we'll spend a minute about that. This is a little bit older news even than ASCAP and BMI, because they, as you probably know, they reached a settlement following some also antitrust lawsuits where the RMLC was claiming they were charging exorbitantly high rates, which they are seeking very high rates in conjunction with their market share. After many years of languishing, there were competing suits because the GMR countersued, it got consolidated in California, and it settled earlier I think it was earlier this year. And the RMLC and GMR agreed on rates under a 4-year license beginning in April of this year. And there's not a lot of information out there about how those rates, that's public, about how those rates were calculated, but I can tell you from counseling some stations here that they are extremely high rates, especially compared to ASCAP and BMI. So, you know, the fact that this settled was really unfortunate, that there wasn't, you know, the litigation wherewithal, I think, to the funding to keep that lawsuit going to reach a litigated result. But it is what it is now. There are these GMR rates out there. They may or may not make sense for your stations to accept. If you play GMR music, you don't really have a lot of choice, because GMR will probably tell you that's the only game in town. If you want to play their music, you've got to pay the piper, and you've got to pay them at a really high rate. There are exorbitant increases in those rates. I think from year 1 to year 2, I've seen annual increases of as much as 30%. Which is, if you think about it, that's pretty shocking, even with inflation as what it is. And then increases yearly after that, that also in a normal time would exceed the cost of living. So another alternative for you may be, as I mentioned before, the NRB MLC. They are in separate negotiations right now with GMR. There's no agreed rates. Perhaps they will do better, but there's no guarantees of that, because GMR may kick in its heels. We just don't know where that will end up.
Hey, Karen, right around this time, and maybe some of the people who are watching this felt, you know, experienced this. It seemed like GMR was just flooded the market with letters. I got so many broadcast station clients that got these GMR letters, and the question that I was getting over and over again was, okay, well, you know, do I go with GMR, or do I go with the settlement rate that that RMLC negotiated? Does that make sense? Is it an either or situation?
So
or
I would have to see the letters you're talking about,
Right.
but I think now there's just one set of rates.
Okay.
And it's the rates that the settlement rates. And settlement is kind of a misnomer,
Right.
because quite frankly, the settlement looks a lot like GMR's ask. And
Right.
it looks like the RMLC came all the way to GMR's position, more or less. They might have gotten a few little tidbits here and there, but they're extremely high rates. So to my knowledge, they're not, at least no longer, 2 sets of rates
Okay,
out
so
there.
it's just that's it. And was this the one where they had to have a certain number of people sign on for it
Yes.
to be effective?
Yep.
Right.
Yeah,
Right.
and they didn't make the goal
Yeah.
initially, and they kept trying until they did, because it was especially in GMR's interest to make that goal.
Right.
Because
Right. Sure.
they really like their rates.
Well, it sounds like they got a lot of what they asked for.
Yeah,
Right.
they got most of what they asked for. Yeah. Okay, so we're switching now to non-commercial radio. You know, because the Colorado Broadcasters Association represents non-commercial stations, we want to make sure that you guys have, you know, the same and similar information to what we just presented, but the licensing scheme is a little bit different. The same 4 PROs are involved: ASCAP, BMI, CSAC, and GMR. But instead of negotiating with them, including perhaps through these rate courts for ASCAP and BMI, there's something that's called a statutory license that's in place. And what that means is there's actually a provision in the Copyright Act that tells copyright owners they must license their works for non-commercial broadcasting, musical works for non-commercial broadcasting. And they, the statute says you need to agree, but if you don't agree, try to agree, but if you don't, then the Copyright Royalty Board, which I'm guessing most of you have heard of, it's a 3-judge panel that sits in Washington, DC, and they have authority to decide, adjudicate certain types of rates. We'll say a little bit more about them later because they also adjudicate sound recording webcasting rates. But here, they adjudicate non-commercial broadcasting musical work rates if there is no agreement. Those rates are set in 5-year terms, and the upcoming term 2023 to 27, the negotiations just finished for that a few months ago. So hopefully those will get published and adopted, you know, hopefully, I mean, by statute, it has to happen before the end of this year. This category of licensees, typically the non-com broadcasters, break down into 3 different groups in these, like I'll call them negotiating blocks. There's NPR, National Public Radio. There's stations affiliated with some sort of college or other educational institution. And then there's everybody else. There's a default category. And once you remove the first 2 groups, what you've got left are largely religious stations as well as some community stations. So we're going to focus on that latter group. If you're an NPR station, you should contact NPR if you're unsure, if you've got a rate question, ask them, because I believe their rates are set by a private settlement that doesn't get published.
Right.
The college rates are published. They are, and I would suggest if you run a college station to contact your college, but those rates are published, and they're pretty similar to the default rates, and we'll get to that in a minute, except they're cheaper, they're lower because they're college stations. So as I said, but we covered this, as I said before, the 4 PROs we just talked about are all implicated here. Again, they each represent a unique set of works. You've got to get a license from all of them. But unlike the commercial radio licenses, which were % of revenue, these rates are tiered flat fees. And to decide which tier, or to figure out which tier you're in, it's based on your format. And by format, that means music intensity. If there's 2 categories, music and talk stations, as well as your population count. So if you happen to be in a big population area, but you don't make a lot of money, you're kind of out of luck, because you're going to pay higher rates because you have a potential reach of more people. On the other hand, if you're doing really well in terms of donations and what have you, and you're in a teeny tiny area, your rates are going to be low, because how well you do is not factored into how these rates are set. It's how big is your market. If you want to see the rates, I've got a reference there to 37 CFR Part 381. That's where all of these rates are set forth with and there's even something set forth for NPR, but I believe, as I said, NPR overrides those rates through a settlement. So focusing on that latter group, which are the religious and community stations, just to kind of give you a little more detail here. For ASCAP and BMI, there was some good news for non-commercial stations, in that the rates are actually, number one, they were frozen from 22 to 23, and in part due to like difficulties from COVID and what have you. And in addition, there was another population tier that was added. So there was a teeny tiny tier for teeny tiny stations added. And so if you see the red numbers on the right, those numbers either are staying constant or they're going down. So the numbers in this slide show you the range of the potential fees that you could pay. There's tiers that, those are the bottom and the upper endpoints. And as you can see, if you're a talk station, especially in 2022, the lowest option for you was $754. Next year, if your market size is less than 25,000, your rate will go down by about 2/3. So that's good news. And once that rate freeze is over for 2023, 2% annual increases will kick in. Now, these rates are rates that have been agreed to and submitted. They have not yet been adopted, but we don't anticipate any issues with those getting adopted because they were agreed to. And then the other 2 PROs, CSAC and GMR. CSAC rates are going to go up for this category by 15% in the first year, and then the 2% annual increases thereafter. CSAC made a push for a much larger increase than 15, and so in one sense. It's good that it's not going up more than that. But again, if you're a talk station, you're also going to see a little bit of relief if you're in that teeny tiny population tier. So that the new tier applies to CSAC rates as well. So the red number 130 shows you where you can experience some fee relief. Otherwise, your rates will go up in that first year. The good news is CSAC's catalog is smaller, so the baseline rate that 15% was applied to was a lower number to start with. So you'll see an increase, but hopefully it won't be too crazy. And GMR is very interesting because until 2023, non-commercial stations did not have to pay GMR anything. GMR is fairly new to the market, and when the prior proceeding covering 2018 to 2022 was opened up for participants to join it, GMR did not join it in time, and so they lost their right to ask for a rate. So for the past 5 years, non-commercial stations have been able to play GMR music and not pay anything. That's going to change in 2023 because this time around, GMR did participate, but at least for the religious group, there's some good news here as well. GMR, they really focus on the commercially successful formats, so pop, country, contemporary music, rock, those sorts of formats is really where they focus. They do not focus on religious music. And I think they're fairly low in Hispanic music as well, but I don't think they're at zero. But for religious music, which is largely what this category consists of, they have virtually no presence. And so they agreed to what I call a fire insurance rate. And that was the discussions that happened of $50. And that's not $50 a year, that's $50 for a total of 5 years. So you pay your $50 up front. You don't have to say hello to GMR for 5 years in terms of rates. You're done until the end of 2027. So that's good news. And that's really just to handle occasional slip-ups that might get in to make sure that GMR doesn't come sue you for copyright infringement for the occasional song that they might have a partial share of, for example. So my advice on GMR at that rate would be take the $50 and pay them to avoid any headaches down the road. Okay, so that was all about broadcasting. Non-commercial webcasting is different in that no statutory license applies for webcasting. So what that means is the negotiating scheme looks a lot more like it looks for commercial stations, meaning non-commercial entities have to go talk to ASCAP, BMI, CSAC, and GMR, or if they want to the direct copyright owners. Usually it's easier to deal with the PROs. So here, the National Religious Broadcasters, they have a non-commercial arm. For religious broadcasters, they actually have a CSAC webcast license. It's a flat fee, and they're currently negotiating ASCAP and BMI and GMR licenses. They are not in place, but there's some protection from infringement with ASCAP and BMI just by the way those consent decrees operate, which says if you ask for a license, you're insulated from a lawsuit, an infringement suit, while those negotiations are happening. And so there will be rates set for ASCAP, BMI, and GMR, but they're not set yet. CSAC rates do exist.
So before we move on to sound recording, which is going to be the next, the actual recording part of the presentation, let's see if there are any questions either in the Q&A or in the chat room.
Still good, I think.
Okay.
Okay, so last topic here is, and how are we doing on?
We're doing great.
Okay. Sound recording licensing. So the first thing to know, this is switching. So MusicalWorks, you remember several slides ago, we talked about the different types of works that adhere in recorded music. So we're switching now to the recorded noise on the disc. And this is something that record companies administer. Typically, they are the copyright holders along sometimes with the performing artists. This is for their performances of the music. And what's interesting about sound recordings is for most of the history, of the United States and the Copyright Act, sound recordings got no copyright protection whatsoever, none. And there were, several reasons for that, but one reason was in earlier days, there was this view that sound recordings were not original enough. Well, first of all, sound recordings are, they're relatively new in our history, newer than 1770.
It's a newer technology,
It's a
right? You
newer
had to be able to
technology.
record, right?
Right, exactly.
Right.
So then, though, people also had the view that they weren't original enough to get the protection, that it's really the composers that they were doing the creating. They were creating the words and the music to a song, and then the performing artists were just rendering what was on, on a sheet of paper. Of course, when you have something like a jazz artist specifically, that argument starts to get a little weaker because you've got, performances of the same exact song. Some can be wildly successful and some not. And so I think it's hard to argue that there's no creativity in a sound recording. And so the first tranche, this isn't on the slide, it's just a bonus point, but the first protection that sound recordings did get, it was not performance rights protection, it was record piracy protection. And that was in 1972, which still, I bet there's maybe some people that were alive in 1972 that are listening to this webinar. Sound recordings had no protection until that year. And because of record piracy that was getting to be a bigger and bigger problem, Congress gave record companies protection against someone taking their, I guess it wouldn't be CDs in 1972, 8-tracks, whatever the technology was there.
My.
Yeah, maybe just phono records and making, pressing copies of them and selling them.
8-tracks.
Yeah. So that was the first thing that was outlawed. And meanwhile, the record companies have lobbied for performance protection, a performance right, which existed for musical works, forever. It did not exist for sound recordings. And record companies tried and failed for any performance protection at all. Then in 1995, for the first time, again, because of technological advances, the internet was becoming more of a thing. It was becoming easier to make digital copies of things, of music. Congress passed a very limited type of protection that applied to certain kinds of, it still didn't apply to radio, broadcasting, or webcasting. It applied to pay services, essentially, like a music choice type service. In 1998, again, this is pretty recent history, 24 years ago, that was the magical year, October of that year, when Congress then expanded the right to cover radio simulcasting, or so said at least one court. There was actually a fight about that. But since 1998, radio simulcasters and also free webcasters like the Pandoras of the world and the free Spotify's of the world. Well, Spotify's in its own category, but the Pandoras of the world that offer a custom radio, generally non-interactive service, they had to start paying for webcasting sound recordings starting in 1998. But when Congress, and still in 98, there has been no broadcasting right at all. There still is not to this day. This right that I'm talking about now is just for webcasting. And
so what that means is that for sound recording, over the air performance of a sound recording by a broadcaster, they don't have to pay.
Yep.
That's the performance tax that the record companies are trying to claw back, right?
Yes. Well, to get a performance. Yes, exactly. So in 95, there was this limited success, and there's a reason for that, by the way. The reason that broadcasters do not have to, and why there's never been in the history of copyright a sound recording broadcast performance right, is because of this recognition that radio has long been the #1 way for record companies to sell their albums. And in fact, if you took away all restraints, if some of you may remember the payola cases, criminal cases, which it's also illegal, payola to accept money to play a song unless you announce it, and no one wants to ever announce that. But if you took away all these rules and just let the free market flow, I like to say, like, which way would that money flow?
Right.
It would probably flow, given the payola cases where record companies would wine and dine and give, trips to Hawaii to the programming directors to get their records on the air. The money would probably flow from the record company to the broadcasters. And, because of this huge promotional value in like breaking a record, that is the main reason why record companies have lobbied for this right for so long and not been able to get it. It's because of that mutually beneficial relationship where radio, they can play these songs without paying a royalty, and record companies are using that as basically free publicity for their albums. And I'm sure a lot of you probably on this call, on this webinar, have seen maybe emails. I've seen a lot of them in the course of my legal career representing broadcasters saying, thank you so much for playing this. You played a huge role in its success, and its popularity skyrocketed. There's a strong relationship here between these two industries, and it just seems somehow unfair and wrong for record companies to start collecting money for something that's benefiting them already.
Right.
And so that's the thinking behind that. So flipping back to, and so as the slide says, there's no exclusive right that record companies get when they're they don't get a right to tell you no to broadcast sound recordings. You can broadcast them to your heart's content.
And I should point out that the Colorado Broadcasters and the National Association of Broadcasters, organizations like that, have played a huge, important, vital role in keeping the record companies at bay on Capitol Hill here in Washington and other venues to keep them from getting that that performance tax, as it's been called, to force broadcasters to pay them for over-the-air performances, which has been kept at bay for yet another year. But you can fully expect the recording companies to keep coming back yearly to try to get that.
Okay, so everything we just talked about for broadcasting no longer applies to webcasting. And I had started to say, as of '98, Congress did create an exclusive right for record companies to control not to control, but to get paid for when you webcast their sound recordings over the internet. And the reason for the distinction between broadcast and webcast, and if you look back at the kind of the thinking behind that split, was that once you're webcasting, it's a digital performance, it's easier to copy, so there probably should be some protection there. Now, this is also not on the slide, but when this protection was first created, Congress created this three-tiered, three levels of protection, essentially. We talked about the broadcasters getting no protection. And before we get into webcasting, the level of most protection is interactive services. So at the same time, actually earlier in '95, that Congress first created this right, interactive services, and what that means is on demand. I think of Spotify, where you can go in and type an album name or a song name and hear it right away. That's an on-demand or interactive service. If you operate one of those on the side from your radio business, the licensing is a lot harder and a lot more expensive because you've got to go negotiate with the record companies directly. This webcasting category that is administered now by SoundExchange is in the middle. It's some protection, but it's not that full protection where the record companies have the right to tell you no. It's under, again, a statutory license, which means Congress can put some controls on the way that, on the rates that get set. And the reason, by the way, for these statutory licenses is typically when Congress wants to make sure that the copyright owners won't be an impediment to this, like in this case, this music getting played, music getting shared. And this was also true, you may remember a few slides ago, on the non-commercial broadcasting of musical works. Congress decided they wanted to make it easier to broadcast musical works. In that case here, they wanted it to be more difficult than no protection, but easier than having to go to record companies, which might demand crazy, ridiculous high prices or tell you, no, you can't play our music. And so Instead, it's this middle ground where you start out by trying to negotiate rates, and typically these are, you either can negotiate with the labels directly, or in some cases you can negotiate with Sound Exchange. The only caveat, Sound Exchange is the collective. Probably all of you, if you stream, you've heard of them before, but that is an organization. It used to be part of the recording industry. It spun off many years ago, and now it's its own thing. And it administers this right. It sometimes, especially in the non-commercial context, it has negotiated, they call them settlement rates, that they don't represent all of the labels, but there is a mechanism for those rates to be adopted as the agreed upon rates, just as we talked about with ASCAP, BMI, CSAC, and GMR. With non-commercial broadcasters, Sound Exchange can sometimes, in the context of a rate proceeding, negotiate for everyone, and that's a little bit easier. But again, you can also always, if you want, negotiate with record companies and just do that private agreement. That would mean whatever agreement you reach would only apply to works that you're playing out of that record company's catalog. So it's more cumbersome to cover the gamut of the works you play. Sound Exchange, as I mentioned, they have negotiated rights for example, NPR stations that would cover everyone. And the way they're able to get those rates to cover everybody is they submit them to the judges in the context of these 5-year proceedings. So under the statutory license, you try to negotiate rates. If you're not able to, you litigate the rates, and the judges in this, the 3 judges on the Copyright Royalty Board set the rates, and they're set on 5-year cycles. And so the current term is from 2021 to 2025. And so Sound Exchange for these non-com groups, and sometimes for aspects of the commercial rates, they've negotiated a settlement, they submit it to the judges, and then once the judges adopt it, it can then apply to everyone, if that makes sense. So if you would like to see the rates, they do differ for non-com, and we have slides on this as well, but they're different rates, whether you're a subscription service, you pay more, and that means a pay service. You pay, your users pay you to access your content. That's typically not true. I don't think it's ever true of a straight radio simulcaster, but you might have a side channel that you're charging for. I think I've heard of 1 or 2 broadcasters that have tried that online. And if you charge for it, just know that you'll owe a little bit more for that. And then if you're non-commercial, we'll get into the details later, but your rates are different and a little bit lower than if you're a commercial webcaster. So, but whether you're subscription, non-subscription, commercial, or non-commercial, all of those rates include both a minimum fee and a usage fee, depending on how many performances you make. So as you see in the last bullet, the usage fee, it's charged on a per performance basis, and a performance is not what you would think perhaps it would be, because it incorporates a listenership element to it. So you might think if you play one song, you put it out there on your webcast, that's one performance, but that is not actually how the statute defines, how the regulation defines performance. It is, if you play one song, one recording, and one listener hears it, that is one performance. If you play one recording and there are 10 webcast listeners that hear it, that would be 10 performances. Right. And so even though, and I'll switch this so you can see what these rates are. I'll flip to the bottom bullet here for 2022, the non-subscription rate, so that would be for your typical radio station that's on the internet, $0.0022 per performance, or 0.22 cents per performance. Might sound like a small number, but you would be amazed at how quickly that adds up to very expensive rates. Because if you've got, and it goes up,
you've got tens of thousands of listeners, that's tens of thousands of performances.
Yes,
right?
And it's gonna skyrocket very, very quickly. Right. So these rates are actually pretty high. But starting up at the top with the minimum fee, these are commercial rates on this slide. It recently doubled from, it had been $500 for a really long time per station or channel. So if you're a broadcaster with 10 channels, you, up until 2020, you owed $500 per each of your channels or your stations, 500 times 10, for example. That rate now has doubled to $1,000 per station. And the good news, some slight good news, is it is recoupable against your usage, meaning that you pay the $1,000, you never get it back because it is a minimum fee, but your first few performances then will not incur a separate charge until you've used up. It's like a consumption. You first get to consume your $1,000 before you have to pay more. So that's at least a good part of it. And the rates that you see here, the 0.0022 and 0.0028, they are subject to annual cost of living adjustments. So I think especially this year, with inflation is what it is, being what it is, you'll probably see some increases to those rates as we go forward. And that applies for every year through 2025. Then on the non-commercial side, the same minimum fee applies, but the one key difference, and it should be a bigger difference in my opinion, but at least it's this difference. Instead of the $1,000, instead of your performances starting to incur immediately against the $1,000, you instead get a free bucket of listenership per month. And it's $159,140.
How did they come up with
yeah,
that one?
I was just thinking, I was going to say, don't ask me where that number comes from. I've done it long enough. I actually know where that number comes from. So in 2004, there was, in a prior rate proceeding, 2 or 3 cycles ago, there was an NPR station survey that was introduced into evidence, and it purported to show that the average listenership of an NPR station is 218 average listeners. So it was based on a study that is now like over 15 years old. Their listenership has probably gone way up since then. But that number, despite valiant efforts to raise that number, the judges are just stuck in this number at 218 listeners. So because it's average listeners, your audience could spike during the day. You could go up to 1,000. But if your overnight hours go down enough to make up for it, as long as you're averaging 218 average listeners, that's what this number represents. You would only owe, as a non-commercial simulcaster, the $1,000. I should also note that there are two, just like in the non-commercial broadcast rates, there are 3 categories of non-commercial webcasters here. I am talking about the default, I'll call it the default category. So NPR stations are subject to a completely different rate scheme. It's a flat fee that was reached in a settlement with Sound Exchange, and it ends up being a lot more favorable than this scheme is for the stations in this category. But if you're an NPR station, you don't need to worry about these rates because NPR is taking care of this for you. You might owe them some big membership fees, but the Corporation for Public Broadcasting is actually paying your royalties to Sound Exchange. So that is a huge benefit of NPR membership. If you're a college station, you do have a separate rate scheme, but the rates themselves are the same as these rates. It's the same system. Really, the only benefit of those rates, and this is a big benefit for some small college stations. And by the way, the college group in this category is more restrictive than the non-commercial broadcast category in that it only applies to student-run stations. So if you are a college station and you're not a member of NPR and you're not student-run, you're professionally run, so you're not staffed substantially by students is the actual language, then you will have to pay these rates. But if you're student-run, you will essentially pay these rates, but you'll get some reporting relief, which we'll get to in, I think it's the next slide. So these are the rates. Actually, it's a couple of slides. Appeal, this slide is about the appeal of the rates we just talked about. So after those rates were reached by the Copyright Royalty Board, the webcasters like Pandora and Google, they were, I was gonna say pretty happy, I'll say not unhappy enough to appeal. So they did not appeal those rates, which represented, it was a big increase in the minimum fee, and I think it was about a 15% increase in the per performance fee year over year from 2020 to 2021. So they did not appeal. The broadcasters, on the other hand, were very unhappy with that, especially the fee doubling. And in the non-commercial broadcasters case, they were very unhappy with getting treated so differently from NPR. So the two groups of broadcasters both appealed. They've got their own grounds. Commercial broadcasters are unhappy because they made a very strong case that simulcasting should be charged less than custom radio like Pandora does. So all of those issues, and believe it or not, Sound Exchange also appealed because they said the rates are so low that their opportunity costs weren't even getting covered. And so they're pushing for the rates to go higher on appeal. The broadcasters want them to be reduced. The briefing is going on right now for that appeal, and there won't be a decision for a while. But in the meantime, you need to pay the fees that were on the prior slides. So the fees are what they are. If there's an appeal that reverses or vacates any of the prior decision, there'll be some sort of true-up process. Well, where you'll either get a refund or you'll be charged an extra bill depending on who wins in that appeal and any follow-on proceedings. So last slide, just a few words on sound recording reporting, and this relates to these webcasting licenses that we've talked about. So in addition to paying your fees, there are two types of reports that Sound Exchange needs from you and that are required under the regulations. The first is called a statement of account, and that's essentially a report of how many performances you made. And that is due monthly for every month in which you actually owe them another fee, which is not always the case for non-commercial broadcasters. So if you're non-commercial and you stayed within that allotment, that bucket of streaming, you don't need to file this report under the regulations. If you're commercial, typically you would file it even when you've not consumed your $1,000, just because you want some sort of a housekeeping record to show when you've gone over your minimum fee and you start owing those extra royalties. So the point of that report is to tell you and Sound Exchange how much you owe, and you're reporting essentially your performances. The second type of report is called a report of use. And the purpose, and that's either filed monthly or quarterly, and the purpose of it is to tell Sound Exchange who they need to pay that money to. So you're reporting what you played, so what works are triggering performances, and then Sound Exchange takes the information that you give them, telling them what you played, that it's fields like the title, the artist, typically the album and the label. There's some other fields as well and some alternates, but you're typically giving Sound Exchange enough information to identify the recordings that you played, and then they take the money that you paid, they divvy it up, and they pay it out after they take their very substantial cut for doing this admin work and for paying for any litigation that happens. They take the rest of the money and they pay it out to the record labels and the performing artists who are whose works are getting played. If you are what's called a minimum fee webcaster, meaning you never go over the $1,000 minimum fee, your audience is teeny tiny, you only have to submit these reports of use quarterly and for 2 weeks during that quarter. But for everybody else, if you're paying more than that minimum fee, they're due monthly, and you have to report every sound recording performance that you made, except for certain types of incidental background performances. And both types of reports here are due 45 days after the end of the applicable reporting period. And while there are many ways to get them filed, still through the mail if you want, the most convenient way, probably for you and for Sound Exchange, is to use a portal that you can reach through Sound Exchange's website, which is soundexchange.com. It's called Licensee Direct, and you can set up an account with Licensee Direct and then log into that and file both types of these reports. You can make your payments that way, and it's probably the easiest way to go for most people that are, at least if they're somewhat tech savvy. So, and with that, we are at the end.
Let's check to see if there are any questions came in either on the Q&A page. There's one, Karen. What is the suggested path for setting up a new account with ASCAP and BMI for a new broadcast entity that best protects the new company?
So if you mean, if it's for a new radio station that was not broadcasting before, as opposed to if you bought a station, I'll start there, I guess. If you bought a station from someone else, typically what happens, I think, is you would just kind of take over their operations. There'd be licenses in place. I think there's certain terms in those licenses that would apply for if you're buying it. And you would want to make sure that you don't have any liability from, if you bought it from a deadbeat, for example, you wouldn't want to assume that liability. So you'd have to make that very clear. If you are a completely new station that is just, gotten your construction permit and a new license, you might start with actually, before you talk to ASCAP and BMI, and they actually do have some pretty helpful licensee representatives that could help that, but especially if you're concerned about protecting your rights, it'll also depend on the format of your station. Again, if you're religious, I would send you to the NRB MLC to at least have a conversation with them. If you're anybody else, I would say call up the Radio Music License Committee in the first instance and get some advice from them. The rates are fairly standardized with ASCAP and BMI. As I said, there's these two sets of licenses and you'll be under either one or the other. They actually have it's called a non-discrimination provision under their consent decrees that says they can't charge similarly situated licensees different rates. They've got to be even-handed in the rates that they charge. So I would start with contacting the RMLC. That question, I think, is also going to depend on your particulars. So if you've got a broadcasting council or a copyright council, you might have a conversation with them as well to deal with your particulars.
My experience has been, I do a lot of broadcast transactions, is that especially if the seller owes a lot of money to ASCAP or BMI, they monitor those stations to see if they're going to be sold. I've seen situations where ASCAP and BMI, they will go in and they will file liens, against stations so that, they basically prevents them from being sold until they get their bill paid. But if you're the buyer in that situation, by and large, you're going to sign a complete, you're not going to assume the seller's ASCAP BMI arrangements, or certainly not their debt. And you're just going to do a brand new arrangement with ASCAP and BMI under the name of the new entity. And yeah, there are contacts that you can reach out to set up those relationships with ASCAP, BMI, and CSEC and others as a new owner, whether you're buying the station or whether you're a brand new station. The one thing you might want to be careful though is that if it's a stock transaction and you're buying the stock of a company, then if that company owes a lot of money to ASCAP and BMI, you might be assuming that debt. So you have to be careful with the stock transaction. We got another question here about podcasts. How about podcasts? Are they subject to the same performance fees?
So podcasting is interesting.
And that's a topic all its own, right? I mean, it could be a whole webinar by itself, right?
It could. It's interesting and complicated. So I believe because when you start talking about podcasting, you would need to make sure the musical. You remember that we can maybe let's go back to. Can we get back to this beginning of the slide? Just to illustrate this. Okay, it was way at the beginning. This slide right here. So, podcasting is a really good illustration for this matrix here. When you podcast, you're not just making performances of the music that's embodied in a podcast. If you were embodying music in a podcast, you're distributing a copy to the public. You're making a copy every time you're sending out that podcast for someone to listen to. It's assuming if they can save it on their drive, that's an extra copy that's being made. So the performance box, which is what we focused on in this webinar, that top line of this slide, I believe that, for example, the BMI license actually covers podcasting, but it would in this matrix, and you would need to worry, see there's 6 boxes over on the right. The BMI plus ASCAP plus CSAC plus GMR, you would want to make sure all of those licenses covered podcasting. And sitting here today, I don't know that they do. I believe BMI's does, but that would be 1 box out of 6. It would be the public performance of musical works. You would then need to worry about sound recordings, and everything we just talked about for sound recordings does not apply. The webcasting part does not apply to podcasting, because podcasting is interactive. It's somebody clicking on something to hear it at a certain time. There's a rule that applies to a certain type of archived programming, which you could argue a podcast would be, but the restrictions are so rigid that it's not going to cover your typical podcast. In other words, if you, just because you asked, if you have a program that's at least 5 hours long and you don't make it available for more than 2 weeks, then you can pay those sound recording webcast royalties. But again, most podcasts are nowhere near 5 hours long. And what that means then is you would have to go to the record companies. You don't have this statutory mechanism, and you would have to negotiate with every record company to give you the performance right, the reproduction right to make copies, and the distribution right. I mean, I guess the silver lining is once you go to the implicated record companies, they can license everything in one fell swoop, as opposed to like the Sound Exchange royalty, webcasting royalty, or ASCAP, BMI, and CSAC. They only administer one of these rights, the public performance right. So all that to say, podcasting is really complicated, especially if you want the right to play whatever music you would like, as opposed to you would like to add 1 song to be your intro song. That's a little bit easier, because if you're talking about 1 song, it's easier to figure out I wouldn't deal with anybody on this list for that. I would go straight to the publisher, straight to the record label of that song, and tell them what you want to do and get a direct license from them, because that would be I'll say 2-stop shopping, 1 stop on the musical work, 1 on the sound recording side. The other thing you could do if you want more than 1 song, but you're willing to limit your music that you use in a podcast to 1 record company's catalog, for example, Universal Production Music, they purport to have a catalog of music, and I believe they claim that they can license both rights, the musical work and the sound recording right. You could, for example, go to them and tell them about your podcast and say you'd like to be able to use kind of all you can eat, a blanket license for their music in your podcast, and see what kind of price they would quote you. So those are some ways around it, but it is a tricky area.
Podcasting may be a subject for our next webinar series here, and take that up. Any other questions? Can stations structure themselves organizationally in such a way so as to minimize these fees?
So for starting on the musical, I think that's harder now than it used to be. And I'm thinking of the sound recording side, but on the musical work side, I think because they're percent of revenue fees, and the revenue is just the revenue you're receiving from broadcasting, you would have to look at the specific definition. But in terms of like how many stations you have or what have you, there may be tricks, that would require some review of the license to see exactly what revenue is swept in to those buckets on the musical work side, and to see if there's a way to exclude some revenue or not. But it's typically going to pull in, all forms of revenue that you're making from your radio broadcast. And so that's really, I think, more of a business strategy question in terms of analyzing the license to see if there are ways to legitimately. I wouldn't want to play games here, because these companies, especially BMI, they will audit you and they will take you to arbitration if they think. I've handled one of these for someone. They will fight hard to get money if they think that they're due some money. On the sound recording side, it used to be the case, again, because it's triggered by a performance fee. The structure of your station it doesn't matter as much as what you're playing. And the minimum fee is a per station or per channel fee. It used to be a per licensee fee. And so I would have said back in those days, it's better to file, one service with multiple stations to save on the minimum fee since it applied to everyone, and you might be able to have saved a little money, but that's not true anymore. Now it applies to every station. So it's a little hard, but I guess the bottom line is there may be a little wiggle room on the musical work side, but you would have to look at that revenue definition to see what you can put into it and not.
Well, that sounds great. I think that's all of our questions for today. Karin, maybe you can put your contact information back up there, but I want to thank my partner, Karin Ablin, for the presentation today. Karin runs our firm's, there's her contact information there. Karin heads up our firm's music licensing practice group here. So so she's the one to go to for questions in this area. I also want to again thank the Colorado broadcasters and Justin Sasso for the opportunity to present this webinar. This webinar will be posted on YouTube along with all the other webinars that we have in our webinar library there on YouTube. So I invite you to go there to take a look at it. And again, I want to thank everyone, and we'll see you at the next one.
Thank you.
Okay.